Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In this video, we are going to discuss a medical negligence case from Jharkhand High Court. If any death is caused due to failure of the operation by a quack doctor, it would amount to Section 304, Part 2 of the IPC, culpable homicide not amounting to murder. This is what is stated in the case of Nimai alias Nimai Chandra Ravani versus State of Jharkhand. Criminal Appeal number 445 by 2024, decided on 6/5/2024 by 2 judges bench. Justice Rangon Mukhopadhyay and Justice Deepak Roshan. They held that the quack doctor terminating the pregnancy without consent is convicted for 7 years RI. Of course, previously was convicted for life by the trial court. Their sentence is modified, but conviction is justified. Before knowing the facts, let us have a recapitulation regarding the medical negligence. We have to admit that even in the cities, even in the towns, if you are having high temperature, what will you do? Immediately you go to the neighboring known medical shop who will prescribe you some anacin or Saridin or things, or presently Dolo 600. So the basic doctor is your medical shop person. Then if it is not cured, where you are going to go? Particularly in rural areas, they will go to the PMP or RMP, private medical practitioners. So they will do something, some treatment. And the RMPs, they are the state guests for the corporate hospital. For example, Sangamitra Hospital. They conduct yearly meeting to the RMP doctors because they refer these people to these hospitals and they will give some presentations to them. RMP, that means most of the PM, I can't say most of the, some of them, they are not qualified, but they will perform anything they like. In the great olden days, there are certain care called as Mantrasani. They used to conduct the so-called miscarriage operation because of the prestige and other things. Abortion. వాళ్ళు చేసేవాళ్ళు ఉమ్మెత్త చెట్టు అని కరెక్ట్ ఉమ్మెత్త కాడని మళ్ళీ వెజైనాలో తిప్పితే యూట్రస్ ఇది ఫీటస్ బయటకు వచ్చేది అనేవారు. ఇట్ వన్ ఆఫ్ ది నేచురోపతి మెథడ్స్, దాన్ని మనం కాదని కానీ తప్పు, because they are not qualified. So with this background, let us go to the facts of the case. Vimala Devi, she is the victim, she is the deceased person. ఈవిడ బారిపద అనే ఊర్లోంచి లేదా కాత్రాస్ ఆ ఏరియా నుంచి, జార్ఖండ్ ఏరియా. సో she was feeling stomach pain. She was pregnant and she was feeling stomach pain. She went to the local Saraswati clinic run by the so-called Nimai Chandra Ravani, who is an RMP doctor, who is not a RMP doctor, he is a quack, directly to say. She approached him and so he has performed an operation without her consent in which her fetus was removed, as a result of which her health deteriorated, lot of bleeding is there, and in the uterus the fecal matter deposited, many complications. She was shifted to Nikhil nursing home nearby. She was taken to Nikhil nursing home nearby. There in the Nikhil nursing home on 14/6/2009, the local head constable came to her and recorded her statement. Basing on that, they registered a case in crime number 126 by 2009 under section 307 and 313 of the Indian Penal Code. Ultimately, after 2 days, she died and the section was automatically altered to 302 IPC, murder and miscarriage. So the investigating officer noticed that this man does not have any RM, that is registered medical practice number. He is a quack doctor. As a quack doctor, he cannot perform any operation. So they filed the charge sheet automatically against him. The trial court, satisfied with the investigation, satisfied with the evidence of the witnesses, they have convicted the accused Nimai for life imprisonment. Then the matter was taken to in the shape of appeal, it was taken to the Jharkhand High Court. Jharkhand High Court now reduced it to 7 years. Actually, already 10 years he suffered in jail. The punishment is 7 years, therefore now he walked out of the jail. Right? How this thing happened? What are the grounds? As advocates, you have to hear the defense. Defense, that is, on behalf of Nimai Chandra, he is falsely implicated. The police or the prosecution utterly failed to prove the case against him. Where did she die? She died in her house after taking away from Nikhil nursing home. The fault lies with Nikhil nursing home, not the doctor. And of course, consent was taken, even though not in writing. She herself consented to go for abortion. These are the defense pleas. Of course, as usual, the state said that he is a quack doctor, he is not supposed to do anything, it is nothing but medical negligence. He has got the knowledge that if the operation botches up, the person dies. So since he has got the knowledge, and definitely it is a case of murder. Now, Honorable High Court said that the circumstances revealed that the accused has no intention to commit the murder. He is a quack. No doubt he is a quack. It is common in rural areas to repose faith in quacks. We can't help it. So please remember, the victim might have wanted to eliminate or get herself aborted. But evidence is not there on that aspect. At the most, it comes under 304 Part 2. So the punishment is, they have given award is 7 years. Already he was languishing in jail right from 2009. The period is over. So he came out he walked out of the jail. So please remember, this case will be useful to you as a medical negligence case and also best example for culpable homicide not amounting to murder. Read the case law and enrich your legal knowledge. Thank you.